We're talking today about a ruling that just tax court case that just came down, overturning an IRS ruling from 26 years ago that we've always thought was wrong. This involves foreign investment into U.S. partnerships where the partnership is engaged in trade or business, and whether the sale or disposition of that interest in the partnership has to be treated as effectively connected income because the assets of the partnership were used in the trade or business in the United States.
Right, and Revenue Ruling 91-32 took the position, that, which I think is an extreme position, that the sale, the gain was determined by reference to pure aggregate principles. So the IRS asserted that what had happened was that the foreign investor sold its indirect interest in assets of a trade or business, which would be subject to U.S. tax if the IRS was correct. However, the tax court ruled last week that the Revenue Ruling 91-32 was not correct, and in fact took a very strong entity view of partnership redemptions, which are analogous to sales of partnership interests, to conclude that that gain was gained from the sale of a capital asset.
And this issue comes up frequently in the asset management world.
Right.
That's where you most commonly have foreign persons investing in U.S. partnerships or U.S. LLCs that are engaged in trade or business in the United States, but it comes up outside of the asset management world as well. So once it's determined, as the tax court has now, that the entity theory applies, now the second part is that doesn't mean the income is not effectively connected. So the tax court went on and looked at whether an office of the foreign partner was actively or materially involved in the sale. Concluded it was not. That, to make a long story short, detailed more in what we wrote up, that made up foreign source income, and most foreign source income is not effectively connected income.
Yeah, no, so that's definitely good news for investors, and investors who have taken the position in the past that they have had U.S. taxable ECI in connection with a sale of a partnership interest or a partnership redemption may want to reconsider that position and perhaps file a claim for refund.
On the other hand, if there was a loss on the sale of the partnership interest, investors may want to continue to rely on the ruling, which they can do.
That's a fair point.
Yeah.
The IRS has an opportunity to appeal. No one knows what's going to happen, but within 90 days or so, we should have a pretty good idea on whether we're going to continue to look for further developments in the case or go forward.
Yeah, and the IRS has several options. They can appeal the case. They can non-acquiesce in the case. They can reinvigorate a regs project they were planning to have on this, but I think the court case is going to make that very hard. Or they can pursue legislation. So there's more to come.
Yep.